Thanks everybody for attending. So you're here for Protecting Employee Assets, the Life Cycle of the Employment Relationship 2025. This is webinar number 6, the penultimate webinar. It's so hard to say goodbye, minimizing risk when terminating employees. I'm Chuck Ruhl, the moderator, as always. This webinar is part of the Protecting Employee Assets, the Life Cycle of Employment Relationship 2025. Slide 6 of the PowerPoint provides a summary of the series on this episode. Slide 4 is our typical disclaimer that we're not your attorneys, you're not our clients, you can't go out and make important business decisions based on what you learned today. This is really general educational material to help you understand the environment you're in relative to labor and employment law and HR management related issues. Regarding the slides, we will be referring to the slides occasionally as we go through this discussion, but the focus is really on the discussion amongst the panel. As always, the panelists are Max Barak, partner of the Garfinkel Law Group. Max is on vacation this week in Florida, so that's why you see the background there and all that. As always, the professional, he's here.
If it's not a trademark or intellectual property issue, I can get as a picture of the Magic Kingdom, but I don't want to cause trouble for financial employees, so maybe I'll stay out of it.
Well, thank you. So President Helen Black, Law Office of Helen Black, and Amit Bindra, the partner at the Prinz Law Firm. You can find out more about us on slides 33 through 36 of the PowerPoint. If you're attending this live, you can ask questions through the web portal. We monitor that. If you're watching this on demand or have questions after the webinar, you can send an email to info@financialpoise.com. Besides your question, include the name of the webinar, and we'll do our best to get you an answer as soon as possible. Thanks to our sponsor, the National Law Review. That's on slides 3 and 37. And with that said and done now, we'll get to the actual substance of this. So let's start out with you, Helen.
Sure.
Regarding termination, this always comes up. The concept of employment at will. What does that mean? Is this like a get out of jail card for businesses?
Well, thank you for asking.
Get out of jail free card. Sorry.
I knew what you were saying. It actually is supposed to work equally in a way for both sides. Employment at will means that either the employer or the employee can sever the employment relationship at any time for any reason, as long as that reason is not an illegal reason, especially from the employer side. So here is what I mean by that. Employee can decide, I just don't like working at this place. And if they're an employee at will, which is usually the default, they can say, you know what? I don't want to come back after lunch to my job. I'm done. And that is perfectly legally acceptable if they truly are an employee at will. And that means that being an employee at will, that they don't have a contract between the employer and the employee for a set amount of time that they have to work. So for example, sometimes you see like C-suite executives will have an employment agreement that they have to work for the employer for at least 1 year, 2 years, 3 years, 4 years, 5 years. So unless you actually have a contract that says that you have to work for a specific period of time, you are going to be deemed an at-will employer. This also means that without providing any notice to you, the employer can say, hey, for whatever reason, we no longer want your services, and can terminate the employee at any time that they want. They can also decide, after lunch that they don't want the employee to come back to work and sever the employment relationship. Again, they can do that if it's not for a quote unquote illegal reason. And what I mean by an illegal reason is, let's say it's not because the person is a member of a protected class and they're discriminating. So you're not allowed to discriminate against someone. You're not allowed to say, hey, we have enough, white people here. We don't need any more white people here. So we are going to get rid of the last white person that we hired. That would be an illegal reason. So as long as it's not an illegal reason, an employer can do it if they have a reason or no reason at all.
Thanks, Helen. So if a business terminates an employee due to a cause like poor performance or violation of company policy, disciplinary reasons, what sort of things do you want to know, as an attorney, if you're assessing if you're assessing the termination or advising the business on that?
Yeah, there's a bunch of stuff. Some of it's based on a separation. Some of it actually might just be based on their employment agreement or their obligations. So on the separation side, I'd want to know, the short version is kind of the basics, like why are they being separated? What is the rationale or the business reason, et cetera? So we can kind of dig into that. Depending on what it is, I may need to then look at the policy that's applicable. So if allegedly there's a violation of the company's dress code or time requirements or something like that, I'd want to just double check what the policy is in the handbook or elsewhere. If it's more work product and quality of work, then I'd want to kind of see what the base of that is and those types of things. I'd also probably want to know what the length of employment is, what the impact is on the business that this employee can't do what they are saying, or what the rationale is for the separation, so I can get a better sense of that. And then a couple other things I'd look into. One is I'd put my hat on as an attorney who represents employees and kind of get a sense of, well, what is going to be the employee's argument here on the separation from a legal standpoint? Are they going to try to allege some form of discrimination or that they were a whistleblower, maybe a cat's paw type theory? So I'd want to explore that a little bit just to get a sense of it, especially if the business rationale isn't great.
Can you explain cat's paw theory?
Yeah, that's a great question. So cat's paw would just be you have maybe two steps up from you, the person who's making the separation. So let's say it's a RIF situation and you have a senior leader who's making a lot of separations based on business reasons. But if the person influencing that decision, maybe a step down, a middle manager, has a discriminatory motive, there can be a cat's paw argument of that person with a discriminatory motive influenced someone else who didn't have that motive, and that led to a wrongful separation. So I'd want to explore those types of things. In a typical RIF setting, a reduction in force, you need to do a little bit less analysis, I think, because theoretically the factors determined for the separation are supposedly pretty standard or objective. So there should be less of these types of issues, but I'd want to look into those. And then the other final thing I'd want to just look into then are the employee's obligations. Helen talked a moment about how most employees are going to be at-will employees. Well, what I'd want to make sure is that there is no term language or clause language in their agreements, no guaranteed severance, those types of things. I'd also want to know what their post-employment obligations are, if any. Do they have a non-compete, a non-solicit? Are they supposed to return property? Just so I can get a better sense, too, of other issues we have to get ahead of. And in a similar vein, I'd want to know what company equipment they have. Are we going to have to be worried about trade secret issues, that type of stuff as well, just to get ahead of certain things.
Thanks, Alex.
Yeah,
I want to say, I'm sorry, go on.
No, it's okay. One thing I neglected to mention, and I thought about it as Amit spoke, is that oftentimes there can be contradictory language, let's say in an offer letter or in some other kind of employment documents, where there is this clear, explicit language that you are an employee at will, nothing alters the at will relationship. But then there's some language, let's say in an offer letter saying, you're an employee at will, but you must give us 2 weeks advance notice if you are going to separate from employment. Now, we know it's usually appropriate business culture to give 2 weeks advance notice, but by mandating the 2 weeks notice, you might be altering the at-will nature of employment from at-will to not at-will, because now you put in that stipulation of you can't leave at any time you want, but you got to give 2 weeks. And you might then have to pay the employee those 2 weeks if, let's say, you didn't give them 2 weeks notice of the termination, because what's good for the goose oftentimes is what's good for the gander.
Yeah, and you you extend that point too to the idea of guarantees or promises contained in policies or handbooks that might contractually bind a business. So,
one other thing to add to Helen's point there is in some industries, I think a notice period, like 30 days notice, 2 weeks notice, is smart, maybe even longer. So take wealth advisors, for example. And that notice period might be an opportunity to shore up client relationships, stuff like that. And so even if you're doing a separation decision as an employer, you may still want to abide by that, even if you could accelerate it or you have language in your agreements to avoid that, just to prevent the exodus of business or other types of things. So you definitely want to circle back to whatever your policies are and notice, what the employment agreement says or the offer letter or whatnot. because there might be other reasons why you want to abide by those, even if you have language in your contracts or agreements that allow you to get out of them.
Right. Another industry.
No, I was going to say medical and medical, like mental health and other.
That's exactly
Yeah.
what I was just about to say. Is that it's very common, especially because there's certain ethical requirements, rules of professional conduct, whatnot, that for patient transition there should at least be 30 days.
Yeah, you want that coverage, and it'll also, I mean, I think expanding on what Amit was saying, it can give you an opportunity to shore up sales or other relationships, or if there is some acrimony, try to put that to bed while you still have somebody kind of on the hook and on your payroll, and have some measure of control, get devices back, get trade secrets and customer lists accounted for, that sort of thing, and to me, it's an area where nickel and diming, again, I think is not always wise. If you've got a business where those customer lists or other trade secrets are really critical, or you need that continuity of healthcare, better to spend the money prophylactically and make sure things are tightened up and everybody's leaving on the right terms and there's no loose ends sort of floating in the wind than getting stingy and picking fights over those quantities.
When I think, to Helen's point too, in physician contracts, that notice period is usually pretty long, and it's usually not something you can accelerate potentially in the sense of like maybe you don't have to have the person work, but you have to pay it out. So that could be a pretty big breach of contract type scenario if the employer doesn't abide by that notice provision or the without quote unquote cause definition of those agreements. That could be an astronomical cost.
I mean, I've brought claims like that before where somebody comes to me with just a small PTO claim or something, but there's like a 60 or 90 day, notice provision in the agreement. And, every state's wage laws are different, but like Illinois and Wisconsin have a very, very substantially similar wage, non-overtime, non-minimum wage payment and collection statute that can be used more broadly than a breach of contract claim with penalties and attorney fee shifting and all of it. And it makes for a nice unpaid compensation breach of an employment agreement claim when you have that kind of language. And I've asserted that on several occasions under that theory.
Yeah, and we're also talking about physicians, so they're making a decent chunk of change. Yeah. And so sometimes they have 90-day to 3 months to 6 months notice provision. So messing that up can be like a pretty expensive cost.
Well, and the way I think of it too, like in some severance situations, I've negotiated, and this is getting a little far afield, but it's not meant to, but some form of garden leave, right? Where somebody's on the books, they're collecting salary for an extended period of time, but kind of a ramp down period. And I forget who had said it, but like, in particular, financial planners, sales, medical, what have you, that garden leave for the business can be useful because that's time when these folks are abiding by certain contractual obligations, presumably. They're not really supposed to be in client contact beyond what you're permitting. And you have time when they're not going to be actively competing with you to kind of shape the narrative and shore up what you need to as a business. So it may be a worthwhile investment for that period in that way as well.
Thanks, everybody. Let's stick with you, Max. So if a business contacts you to get advice about a termination or possible termination, I assume as an attorney, you'd probably ask for the personnel file or key documents. What do you look for or hope to see in these documents before giving the green light to a termination or any sort of adverse action?
So, I mean, I think, I don't want to reinvent the wheel too much because I think Amit covered a lot of this, but you want to know really from go, what are you walking into? If it is a performance issue, like what does the documentation look like? I mean, I'm a broken record every year we do this, but like you really, whatever business you're in, even if it's not a business that's heavy on paper or electronics and record keeping is spotty, you need some kind of system to document these things. Because when you don't have one and you say somebody's getting fired for performance, someone like me on the plaintiff side, if you say, oh, we don't keep records of that, but trust me, he's bad or they were terrible at this, I just sort of ignore stuff like that. Because if it's not documented or you're not keeping records in the regular course of business, I get told as a plaintiff's lawyer so often my client's lying. They're the worst employee who's ever set foot, let alone work there, has ever set foot within the four walls of that building. God help them for whatever, and if it's not on paper and they can't show me contemporaneously that that's really being documented, I tend to ignore that stuff. If it is a disciplinary issue, what is the policy? Are you actually following your progressive discipline? Ahmed, I think, had mentioned attendance. Like, what is your attendance policy? Is it first time's verbal, second time's written, third time is, you're on a PIP or you're fired? Do the violations roll off? Are you trying to nail somebody for an attendance violation that's a year and a half old? Because I'm going to start asking questions if you're like, hey, they have attendance issues, and you're like, oh, great. Well, what is it? Well, a year and a half ago, they were late 3 times, but we haven't done anything about it in a year and a half. My next question is, what did they really do that you want to fire them for right now? Because that seems pretty pretextual. You want to know, like, have they engaged in any protected activity recently? Amit and Helen both, I think, talked about discrimination and discriminatory complaints. If somebody's been running around reporting what they think is discrimination, whether you think it's valid or not, your solution can't be, this person's so annoying, we just got to fire them. So I want to know, have they been raising whistleblowing complaints? Have they been claiming they're being treated differently than folks? I want to know what kind of documentation exists business-wide. Do you have more or less for this person than normal? What are your typical practices? And I'm also going to want to know, what are their job description? What are their duties? Is that why they're getting let go? Show me why they're not doing this stuff. Because at the end of the day, the business owner and the business are the decision maker. But if you're hiring someone like one of the 4 of us on this call, you're doing that presumably because you want and trust our advice. And we want to be able to make an informed recommendation to what you're doing. So I need to know this sort of background to understand that. I also want to know, what does their agreement look like, and what sorts of wages are they owed? What kind of benefits are they getting? What kinds of questions am I going to get at the termination that aren't, F you, I don't deserve this, but what are my rights? What's going to happen to my benefits? I need to know what those benefits are and what the legal obligations are going to be so I can advise on that intelligently and completely. So, you're going to need kind of a comprehensive item.
So we got an actual question online here. It has to do with quiet firing, I guess, like the opposite of quiet quitting. And I've been hearing more stories in the media lately about quiet firing. I guess in a general sense, so I don't want to get too specific about it, but if a company wants to end all remote work, the pandemic related remote work, is requiring office time for all employees within 50 miles of a company building or company building location. Can we do this as an employer, or is this a form of quiet firing? I guess now that they're also given 90 days notice of this change in remote work, and they're requiring now 4 days of in-office work. I hope I said that right.
Yeah, I think the question basically just is like, if people are working remotely and you say, come back to the office, can you do that? I think the short answer is yes. I know a lot of companies are doing that, where what they did do or are doing is, in lieu of, and I think Helen's going to talk about this in a moment, in lieu of giving out severance, companies will require people to come back to the office because they just expect those people won't, and they'll just quit on their own. And I think that is probably one way to handle these situations. And then from there, companies can kind of determine what they want to do. Some will have pretty stringent in-office requirements at the start of the employment during the quote-unquote probationary period, because some people may just opt out then at that point.
Your point on it, and you're right. We were going to segue into Helen now regarding severance. So, what's a good practice, or what are some of the best practices regarding severance? From a business standpoint, I hear this all the time, like, this employee is garbage, which is why we want to get rid of them, and now we got to offer them severance. What are the advantages? And that's it. What are the advantages?
So first of all, there is not a one-size-fits-all approach. It depends on the kind of employee, the level of the employee. It depends on if there's something called a plan that mandates severance under, let's say, ERISA, the Employment Retirement Income Security Act. So there are a lot of different variables. So I'm going to assume, for purposes of your question, that we're not talking about an ERISA situation. I'm going to assume, for purposes of your question, we're not talking about someone who makes minimum wage and they, for whatever reason, they just are not performing well and you want to terminate them. I'm going to assume for purposes of your question, you're talking about someone who's more likely than not a professional.
Yeah.
And it's just not working out. It's just not working out. In that kind of a situation, you have to go through a multi-factor analysis. One factor is oftentimes employers will say, look, this person, is not a bad person. They work for me, let's say, for a year, 2 years, 3 years. We thought it would get better. We're living with mediocre. It just hasn't gotten better. But the person is going to be a little bit blindsided. And so just to be, a nice person, we want to give this person some severance to help bridge them to their next job. That's one scenario. But no one likes to give away money for free. Oftentimes, businesses like things that are wrapped up and tied with a bow, and to minimize risk of exposure or liability, or even just things like, this person is not going to be happy that they're terminated. We don't want them going on social media and bad mouthing us. So there are a lot of different reasons why you might give a severance agreement. But without a severance agreement, you're not going to have some kind of contract that's enforceable in which the person who you're giving the money to has to refrain from doing certain things, like not talking trash about the employer. So if, let's say, a non-disparagement or confidentiality, or just having some assurance that more likely than not they're going to sue you is important, then those are reasons that you're going to want to offer someone who more likely than not is a professional some severance. If, let's say, there is something that you're a little concerned about because that person is a member of a protected class, or let's say they did make comments over the year about things they weren't happy with at the place of employment, even if you are 100% certain that they were just not working out, it's oftentimes a good reason to give someone a severance agreement to get them to waive their claim. So this way you have the more assurance that they're not going to sue you for perhaps some of those things they complained about that maybe you even investigated, maybe even took care of. But that did, beg the question a little bit as to why this person was being terminated, even though you might feel you did nothing wrong and one thing had nothing to do with another and the termination was completely justified. So as you can see, there's a lot of things that goes into the analysis. There are a lot of, reasons why. It could also be you have two employees. You have a very small business and there are two employees part of a team, and these two employees just don't get along with one another. And so you've just decided it's better for the business, even though, the person isn't necessarily a bad employee. You just got to get rid of one of them. And so that's another reason why there's probably going to be some hard feelings, and you might want to offer someone a severance package.
So I'll throw this one out to you. How does precedent or past practice factor into this? I mean, if a company has offered these before.
So,
yeah, I think that's a really valid. Oh, did you want to go? Or
I didn't realize. I thought he was throwing it to everybody. It's your question, Helen. Please go ahead.
Go ahead. It doesn't matter. Anybody.
No, I think it's a really important point, because that could open the company up to liability. So, for instance, if, let's say, historically the company has provided severance, even though it's not ERISA-based and required under some sort of ERISA-based plan, they have in the past offered severance, and then someone is separated from employment and they're not offered severance, they might say, hey, why am I being treated differently than these other employees? I know the company has a history of paying out severance. Why was I not offered a severance package on the way out? And that could make the person sit there thinking that maybe they do have some sort of discrimination or other sort of a claim if they weren't offered a severance package. So I think if a company has a history of offering severance, they should be consistent with their policy and offer severance to those who are similarly situated.
Yes, and I was going to say I've actually come across that in my practice, where I've had somebody where I brought a claim for them post-firing. They worked for a very, very large organization that had, I think, Helen, this probably would have qualified as an ERISA covered plan at this point, just because it was so well entrenched. Like if you've been with the country, not every warehouse worker gets it, but at the executive level, if you've been to X level, depending on years of seniority and what rank you're at within Y level, then you get, it's like a set sliding scale where there's no subjectivity to it. And in the course of these negotiations, sometimes depending on the strength of your claim, you may find yourself sometime going, hey, can you cut my client a deal or just do them a favor? They put in a lot of good years, what have you. And I had this in-house counsel say, look, in the past, sure, I might have thought of that, but we're actually in the midst of getting sued because somebody in a protected class alleges that that's exactly what happened, that like they were bound to this sort of chart, if you will, and there was no deviating, but somebody outside of that class got special treatment. The other thing I'll say is I've now, because this came up in another one of my cases, and it's slightly deviating, but not that much, the decision not to negotiate because somebody has engaged in a protected activity, I've actually seen now survive 12b6 motions. So, for non-lawyers here, people have brought claims, were in negotiations of some kind with a company, felt something discriminatory was going on and basically piped up about it in some way. And that act of them speaking up, whether through any EOC charge or a public statement saying, hey, I think this is racist, led company, this is public. One of the decisions is against Netflix. They were negotiating with a stand-up comedian who was, I think, a person of color who felt they were being given the runaround or not getting access to payment that was consistent with what others had gotten for similar stand-up specials. In the midst of the negotiations, they make some sort of a public statement to that effect. Netflix gets angry and yanks all offers and says basically, F you, we're just not going to do anything with you. And at least at the district court pleading stage, the court held that was still potentially actionable as a discrimination claim. I have now raised that myself because I have one where I was engaged in theoretical negotiations. The company dragged me along for too long and I filed a charge, and their in-house lawyer goes, well, we could have negotiated, but now we won't. And I said, great, you just retaliated. So, you always want to be careful with how you manage those because you can get into trouble, for deviating if you do that stuff. I do tend to think, like Helen said, it's a good practice when you can, because you can buy off someone who's unhappy and might be a loose cannon running around town, poisoning your name and what have you, and just the liability, and what have you. But just be careful in how you apply it, that you're not playing favorites or doing favors for people, because it can have some downstream consequences.
And when I gave all my caveats before,
a quick point on context. Rule 12b6 is Federal Rules of Civil Procedure. Rule 12, motion to dismiss.
Sorry, to be unclear, I was describing it at a national level.
Yeah.
Like the federal rules, basically, like, I don't know if the case is going to succeed, but a judge held that like they had stated enough, and there was no per se bar to them bringing that claim forward. They may lose, but.
Yeah. And also, I know when you asked me the question, I gave a bunch of caveats. I don't want to give the impression by any means that severance agreements are only for highly compensated employees. They are given to employees at each and every level. I just wanted you to understand my analysis a little better and give it some kind of context, which is why when I was analyzing it, I just used the example of, let's say, someone who was like a professional.
Yeah, but that's 100% right. Because in reality, with a severance agreement, there's two goals to it. One is either you're buying something, which is you're buying peace, certainty as an employer of there is not going to be a lawsuit, and it doesn't have to be a high wage earner. It could be any number of employees. Maybe you need a non-disparagement clause. Maybe you need, and when I say you, I mean the company. Maybe the company needs some type of restrictive covenant, confidentiality provision, et cetera. So that's all something the company's getting. The second reason would just be it's a recruitment and retention tool, because they give out severance packages to people on the exit, and it's a way to recruit talent to them regardless of what their wage rate is.
So let's stick with you, Ahmed, for the next question. And this gets into a little bit, a little different area, unemployment compensation. So if a business, well, I guess the simplest way to put it is like, should a business contest unemployment comp when they're letting an employee go, and especially if they're offering employees severance?
So I got to give the lawyerly answer of it just depends. I think it depends on the state. It depends on the circumstances. If it's in some circumstances, the employee might be eligible for unemployment even if it is contested. So, for example, if it's a RIF, in most states, the employee is likely going to get that. So it depends on if it's true misconduct or elimination of a position or a reduction in force. And then I think there has to also be some thought process of, is it really worse to ROI to contest it? Because in some states, the standard is pretty easy for an employee to get it. So an employer could spend a lot of time or hire an attorney to contest unemployment, and ultimately the employee is going to get it anyways. And then the question becomes, was the combination of the legal expense or the business expense coupled with or that expense versus the higher premiums, is that really worth it from the math standpoint? So I think most of the times it probably isn't really that worth it, but I think there is some like cost benefit analysis that employers can do to kind of figure out when do they want to contest and when do they don't.
I think if you're
Here's what I'll throw out.
I think if you're paying them severance, it's not worth it almost ever. And sometimes even if it's not a misconduct based firing, sometimes the reason somebody does end up coming out of the woodwork and bringing claims is because you've cut off all avenues for them, including contesting unemployment unjustly in their eyes. So sometimes it's the easiest. It's a low enough cost effective where, like, if they do have a right to it, setting aside the big money, like, you're less likely to have somebody disgruntled coming after you for it. Plus, a lot of states, not just our state of Illinois, most states that I've encountered have some sort of bar to evidence from unemployment hearings being used in civil litigation. So it may or may not have any practical impact on defending a claim the employee may bring to your detriment. So check your.
What about asking for a waiver of an unemployment claim via severance or separation agreement?
I don't know that that's permitted.
I think
I don't think you can do that.
I think I think that would be void. I think it's against public policy.
Yeah.
I think those are one of those kind of claims that wages, workers' comp, that you have an absolute right to try to file, and it's up to the state governing agency whether to grant it or not. I mean, it's an insurance policy. That's really what unemployment is. Someone's paying into a policy, and if they meet the policy requirements, they should get the unemployment. And I 100% agree with Max. I had a business I just counseled, these last few weeks where for sure this employee should have been terminated for misconduct. They were intentionally taking clients' information and calling them on their personal cell phone to get all these clients' information as opposed to using their business number and whatnot to try to take business. And we realized this person really needed to go, but the person was a loudmouth. And I said, you know what? Don't deny their unemployment, because that person is such a loudmouth. They're going to cause so many problems. They're going to go right to an attorney. I think it's better just to try to calm things down by terminating them, which there was a blow up and the police did end up being called, believe it or not, in this situation. It was, so it really was what my client was concerned about. And the police, of course, went away and said there is, nothing here, some crazy allegations in any event. So a client decided not to. And so far things have been quiet. It's been 3 weeks.
Cool. Well, that kind of leads into my next question, Max. I mean, when you deliver the bad news to somebody, of termination, do you call for insecurity, call the police? And what are some of the best practices? How do you do it via Zoom in order to avoid any face-to-face or personal contact with them?
This is hard. And it's funny that I always think of the movie Up. Whenever we do this webinar, I always think of the movie Up in the Air, where George Clooney's job is just fly all over the country, just like mass firing people.
Yeah.
It just seemed like a terrible existence. I think whenever you can do in person, look, you're going to have random occurrences like Helen's describing, where like somebody is disgruntled or somebody's a loose cannon to blow up, and go back to our first webinar to think about how you vet the people you hire and you try to avoid this stuff. But hiring is hard. I think it really is always one of the hardest things you do as a business owner in any industry. It's really hard to find people that are committed and going to be a good cultural fit. And the fact that you're having to act on what's in this webinar says, for one reason or another, that's already gone sideways. I think in a perfect world, you use in-person communications when possible. If you have heavily remote workplaces, obviously that's not always possible. But I do think face-to-face is an element of courtesy and personalization that can be useful. And I think, look, nobody's happy to be getting this news. Although I will say folks who have real legitimate deficient performance issues that I've encountered in my career rarely are surprised and very often do accept and see these things coming. Obviously not everyone, but a lot of the time they do and they understand it. I think, obviously, like I said, sometimes that's not workable. So when you can't, just do what you can to try to be at least somewhat personal about it. I think people respond better to not feeling like they're being coldly thrown to the ground like a piece of trash, even if you're really upset with them about something that's gone on in the workplace. As far as calling the police and what Helen's talking about, look, if somebody's combustible or has a reputation for violence, use your security as you see fit. Just try not to embarrass people or make a scene when you can. And that really ought not be your standard practice. When stepping back, though, if it's not a one-off firing and you're talking about layoffs or mass reductions in force, that sort of thing, that may or may not be workable. Maybe calling a company meeting if it is an in-person workforce is doable. If it's not, a mass Zoom where you have people there is probably useful. Do assume if there's a layoff or a major closure, somebody may secretly record it. If you're in a two-party consent state, that doesn't mean it's a legal recording or they're doing it with your permission. And you might tell people you don't have my permission to do this, but you know how this goes. Often these things are very political. You think about like the auto industry in a state like Michigan or during the '08 crash or some other sort of homegrown industries that are really inextricably linked in communities. There's going to be a very deep personal an injured reaction from folks that are affected from it who may feel like they gave their lives. So you always want to really have that stuff in the back of your mind. The other thing is if you're doing a mass layoff and you are of a size and nature of a business where the WARN Act might come into play, which is the law that basically, if you think about those old movies where the mill's closing in town and old man whatever closes the mill in the dead of night and ships the job somewhere. This is the law that deals with that, right? That says organizations that close a facility of a certain size for certain circumstances or reasons have an obligation to give 60 days notice or in lieu of that 60 days pay. So you always want to be really mindful of these items and have answers to whatever legal and benefits and comp questions are going to come about, because people are just finding out some really horrific news that their life's about to get turned upside down. And I think showing up unprepared and acting like or appearing as if you haven't really thought about the severity of what you're about to do has a real way of making things harder in the long run and making your life more difficult. So the better you can do to kind of smooth the edges, I'm not saying you have to be best friends with people you fire. They're going to be upset one way or the other, but show up and act like you've taken it seriously and have answers to difficult questions and give people some direction they can walk away with. So they at least have something to grab onto and they may be less aggrieved down the road.
And
thanks for that. So
two things to add real quick there. Max mentioned WARN Acts. States have their own mini WARN Acts that sometimes have broader obligations than the federal law. So it can be a very easy way to trip something up and make a mistake that's going to be very expensive. And in terms of the piece at the end of Max, that I agree wholeheartedly of, if you got to do a separation, you got to do it. You can't really sugarcoat it. So it's just better to be direct and just get to it versus trying to like dance around it and, make small talk before getting to the ultimate decision.
Great point. Helen, continuing with the logistics of terminating employees, is there a best time of day or even like a best day of week to do this? Or what about location, to fire somebody?
I think there is. Oftentimes I will advise clients of mine to not do the termination on a Friday going into the weekend, as most people are inclined to do. It's in a way it's a little bit counterintuitive. And the reason why I say that is because when you terminate someone during the work week, it's during the work week and they're more inclined to start their job search. Other people are generally working during the week. I mean, depending on the industry, I guess if you're working in a restaurant, maybe you might want to reconsider what I said, but keep the principle in mind. But yes, maybe fire on a Friday if they're going to be working. It's supposed to be working on a Saturday, and all their friends are working on a Saturday. But the general thought process is it's best to try to terminate someone when they don't have nothing to do right afterward, but to sit there and moon on how awful it was that they were terminated, so they can be as productive as possible and get right back into the swing of things and not have all this time to sit there calling people, mooning on over how awful it is. Again, this is not a legal standard by any means. It's just best practices in terms of what I've observed oftentimes works well. I mean, certainly you want to try.
There is no legal. standard for
No.
firing somebody. No, there's no law that tells you like the logistics of it.
Right, exactly. That's why. So this is all, essentially just based on best practices, what I've observed over the years, speaking with colleagues, et cetera. It's not like a hard and fast rule. Certainly, if there is someone who is going to ruin your business and is about to explode, then just do it as soon as possible. Sometimes you just have to nip certain things in the bud, like a volcano before it explodes. But assuming this is something that you've seen coming over time, I would be strategic in terms of your timing. I would try to time it in a way where they can leave with dignity, where not a lot of people are around, or perhaps no one else is around. Maybe you do it right at the end of the day where everyone has already left for the day. You ask this person if they could stay a few minutes later and have someone else in the room as a witness, and let the person know as gently as possible. If it is amicable, meaning it's just, the person just didn't perform, but they're still, decent person, I would try to find a positive way to end the conversation, wish them the best of luck, maybe mention another kind of job that might be good for their skill set, that would appreciate the kind of skills that they have. I would not leave them necessarily alone. I would have someone walk them to, let's say, their workspace to gather all of their personal belongings and then walk them out the door. You want to make sure that someone doesn't take company property. You want to make sure that someone doesn't do some kind of a document dump. So you want to make sure that their access to, your system is turned off at the time that you decide to have this termination meeting. And again, do it as quietly as possible so that hopefully others don't see what is taking place.
Yeah, I guess the stress, get all your equipment back beforehand, or as much as you can get back beforehand. Obviously, it's going to set off
keys to the
alarms.
office. Yeah, you ask keys for the office. You have the laptop. You take whatever documents or whatever equipment that they have with them. You make sure you get it right then and there. And if people do work in person, give them the opportunity to take their stuff and go home. Sometimes if there's a lot of stuff, it might just be easier to say, we will send it to you. So this way the person isn't there for a really long time.
I've had that where somebody gets fired who's been there for like decades, and it's like they spend what feels like the whole afternoon cleaning out the office, and it's just, it's sad and it's really uncomfortable, and like
it becomes like a funeral.
It really is. It's just, there's no happy way to do that part of it.
Yeah.
And it's hard.
Yeah.
So Amit, this is a question I get from none of my current clients or my longtime clients would do this. Only I get this question though at seminars and from prospective clients. What about just telling employees that they're being laid off and that, that's not a termination for cause or whatever, that we're just going to lay them off and that's that?
Oh, and then not tell them the rationale for it.
Yeah, yeah, exactly.
I think the problem in that situation the main problem in that situation is the employee is going to think there's something nefarious going on. And those types of questions lead to more headaches and legal claims than not. I think generally an employer is better off just being somewhat transparent about the rationale of the termination, so it doesn't lead to those things. If it's just, we just don't have the resources for this position, it's one thing. If the work's just not, working out, that's another thing. And in theory too, the termination decision it's going to be rare that it's going to be something that's a total surprise. There's probably are going to be steps leading up to it, unless it is a true restructuring or a reduction in force or something like that, or actual cause where there is misconduct. If it's more performance-based, there should be conversations leading up to that separation about, hey, your performance isn't where we need it to be. We need you to improve on this or that. Typically, it would be rare that there's those little steps not happening. And if those aren't happening and then there is a separation, the employee is going to call someone like Max to say, hey, I think I was wrongly terminated. And then Max is going to try to get the personnel file or pick up the phone, and there isn't going to be a good answer. And those are the types of things that lead to legal claims.
Nice. Max, if an employee asks for the employee file, should the employer do like sanitize it before giving it out to them? remove or adapt any sensitive documents or information?
No, I guess is the short answer. I mean, the longer answer to that is, it's really going to be very narrow limits. Depending on if you're in a state that has some sort of a personnel records opportunity. Again, I know this is a national webinar. I know Illinois is one such state where you have a right to your personnel records, and that definition of what that is has gotten a lot more robust. So be mindful of that. But, sort of picking up on what Amit said in his last answer, shifting justifications for somebody's firing in a case about somebody's termination can be evidence of unlawful motivations, whether a whistleblower claim or some sort of retaliation for raising a discrimination claim. So you don't want to start messing with somebody's file any more than you want to start just like making up reasons you fired somebody, because every time you change your position or you move something around, that act unto itself can be evidence of improper motive and makes you look that much more guilty and dishonest, just at a practical level. Yeah. The more excuses somebody gives me for why someone's let go, the less credibility I give to each of them in quick succession. Like every time I get more than one answer, I stop taking them seriously and I start making a list of them so that I can absolutely crush somebody in a deposition with each one of them to show all the contradictions. I think there are some limits to my earlier answer as to the file itself. Like if there are sensitive or confidential references, information that was not shared with that employee that could put somebody in danger, or is somebody's private health or medical information in there, like other than the employee you're talking about. There's attorney-client privilege communications in there. You wouldn't do that, but you can't take negative documents out to make the file look better or create less of a risk to you. You can't redact truthful but embarrassing content that may reflect legitimate performance issues. I mean, you can, but it's not a good idea. And you can't actively, retroactively throw stuff in there to try to paper the file and make it look like they're much worse. I had a guy one time give me a file, and it was like, they were trying to claim all 4 of my clients had been horrible, but the disciplines for one of the guy they put in there were like 10 of them all over like an 8-day period that they had frantically like scribbled in there and thrown in without signatures. And it was just silly. It's like, it leads me to ask their lawyer questions that they can't answer, which is, do you seriously expect me to take these seriously and like act like this is something real and not something somebody scribbled on construction paper in crayon and tried to sell as like their homework? Because that's what it looks like. So don't start deviating from practices. Don't start brushing up against state or federal law on what records you have to keep. And don't start changing why you did things in this file to cover your tracks. Because I got to tell you something, if your employee is litigious and savvy enough to get to a lawyer and is potentially somebody who's sharp and a good self-advocate, they're going to look at that and know exactly what you stuck in there. They're going to disarm point by point every BS thing you've concocted, and it's going to make you look craven and dishonest, like you are doing what it looks like you're doing.
Well, and I'll throw out this point too, that a lot of states permit more than one request to review your file in a year or over time. And so if an employee is savvy enough to do that and like has a complete record of what their file was at a certain point in time, all of a sudden down the line, there's all this new stuff added. That's going to be a red flag to any plaintiff side, or also I would think to any defendant side attorney. And that's going to be problematic. And then this is something we've touched on too in a lot of our seminars and regarding the creation of documentation. Create documentation contemporaneously with the events that you're documenting. Don't just all of a sudden, then you talked about this, have an avalanche of all this evidence of bad performance.
Yeah, and it's like, the contemporaneous documenting is so critical for like every single one of these webinars we've touched on, for like reasons that come up in each of them.
Yeah.
And I know that the compliance, because I've talked to friends who work in this space for large organizations, compliance and legal services is often business owners' kind of biggest headache and where they immediately look to cut. But people need to keep in mind, like those red lines on the balance sheet or on the book sheet, your P&L, whatever it is, like those often keep the other red lines smaller and the black lines bigger. Because if you don't take the ounce of prevention, pound of cure statement of these webinars is really true. Like it's worth the real time doing things the right way when it happens, even if it's inconvenient, not to paralyze your business, but to say that you have standard practices and that you followed them. Because it's so much harder for a litigious employee to bring a frivolous claim when you do it the right way. When you take care of everything and you follow your rules, you can say, look, this person was a problem child. They were late every day for a week. Their first week here, we followed our attendance policy to a T. They even got extra chances. We told them, hey, it's your first week. We want to give you the benefit of the doubt. And it was like they were sticking it to us. Like we did our best. No one was ageist, racist, sexist, anythingist. They just were not a good employee. Here's our ironclad procedures that we followed to a T. Have a nice day.
There are one or two things, though, that if you typically keep in a personnel file, you can take it out. So, for example, certain tax documents or tax records, I-9. Sometimes companies, they really should be keeping the I-9s in a separate file, but sometimes they don't. And so certain documents like that, then you can take out before providing the personnel file to the individual. I think it's
times where you don't know why the employee necessarily is requesting the personnel records. I remember I had a situation one time where an individual was like uber concerned that their prior employer was going to contest their unemployment. And so I just kind of mentioned in passing, well, why don't you collect your personnel file in case they do? And so this individual did, and you could tell they were papering the file because it took forever for this individual to get their file, and it ended up being like a really big file for someone who worked for a short period of time. And I was just kind of helping this person on the side. And I said, you know what? If they do contest your unemployment, the fact that they took so long to paper their file just helped your unemployment claim because it just showed that they thought you just weren't, you weren't performing. That had nothing to do with anything else, like all these other things that they alleged, et cetera, why they gave you the indication that they weren't going to, that they were going to contest your unemployment. And voila. Because I think they thought this individual was going to come up with so many other kinds of things. And really, it was just because they wanted to protect themselves in the event of, an unemployment claim.
And in reality, there shouldn't be anything too sensitive in a personnel file that a company should feel uncomfortable providing to the employee. I don't know why there would be like anything that's quote unquote trade secret or confidential information to the company. So there really isn't a good reason to remove anything.
You can have a test, I guess. Like sometimes you might have someone take a test that's proprietary,
Yeah, so there may be limited reasons, but there's probably solutions to stuff like that. 98% of the time, there probably isn't going to be stuff like that. I know sometimes employees want stuff removed from their personnel file, but they can work with the employer to figure out an agreement to get that done.
By the way, since we're talking about personnel files, an employee can also ask to have stuff added to their file, can't they? Or like amend their file.
Yeah, they can ask for modifications. Yeah. I mean, in reality, or in practice, it shouldn't matter too much to the employee because of those things. The personnel file would only really come out if there's future litigation. But yeah, the employee has some leverage or opportunities in, at least in Illinois, I'm assuming most states, to ask the employer to make change, to remove or add documents to their file.
I'm going to throw this out to all of you as we run up close to the hour. How much you put in writing to an employee when you're firing them, especially if you fire them for cause? And I guess going along with that, what if the employee asks you to put the termination in writing?
I don't. Once in a while, people will, like I'll have clients will say, they ask me to put something in writing and I will say, there's no legal requirement that you put anything in writing. And in fact, I really counsel my clients when they're terminating someone just to say it's not working out. By the time you've decided to terminate someone, you've made the decision. There is no point in rehashing all the things they didn't do and giving someone an opportunity to give all the excuses to why they really did do it or why it should be overlooked. It's just not working out. And that's all there is to it. And I would counsel someone against putting something in writing unless the employer, unless there was something truly, truly nefarious, they want to make a paper trail, and even then I'd be careful. Like, let's say someone was, committed some kind of a fraud or something like that, and you wanted to at least show that you put someone on notice that there was some kind of really nefarious conduct that took place.
I agree with that. I think to just add on to that, I think the only time you'd really want to put something in writing from a cause standpoint is if the agreement with the employee has cause language. So that way there's a difference. If a cause termination means something different than a not for cause termination. But even in those circumstances, sometimes a company may just determine, look, we have cause, but we're going to use the non-cause, language here just so this can be a little bit more amicable. So that depends, but you got to be real careful because calling something cause when it isn't can open up a defamation claim and other issues. So I agree with Helen. I think there are very few exceptions to how to handle this.
What if, and also here's another one I get a lot. You're having the termination or you schedule a termination separation meeting. What if the employee asks to have their representative or their attorney present?
Unless there's a collective bargaining agreement in some state laws and states other than my own that I'm unaware of, you don't have a right to have an attorney present. I know some unions, collective bargaining agreements, I think there's a specific statute or decision that comes down, like they have certain guaranteed rights to representation or having somebody there, but
Weingarten rights.
Weingarten. But for standard at-will non-union employment, you do not have to do that. And I don't really see a ton of upside to having that person there.
Would there ever be, have you ever granted such a request? Would there ever be a time you think to grant such a request?
Usually the employee doesn't know that they're even being terminated. So usually the termination happens before there's ever an opportunity to, to have a representative present. I think maybe the scenario that you're throwing out is more akin to the employee knows that there's going to be some sort of disciplinary meeting that's going to take place. And they know in advance and they want a representative as part of that meeting. Sometimes, or there's an investigation.
I feel with an investigation, employees are more likely to want to have some sort of representation.
Yeah.
What if the employee basically says, look, is this something I should have my own attorney for? Or is this, I don't know why you want to meet with me, but it sounds ominous. Can I have my attorney there?
I would have a policy that says we don't, I don't think it's a Weingarten issue if it's non-union. I would say we don't allow that. You may not. For the same reason I was taught you don't get into an argument with them about why they're being fired. You don't tell them what it is. If it's misconduct and they stole and you're meeting with them to confront them, okay, one thing, but absent that, less is more. It's what Helen said. They're going to argue with you. They're going to want to make a case of it. And there's no upside to convincing that person if they think falling asleep at their desk isn't a big deal, because I've had this experience, and they say to you, well, I wasn't asleep. My head was just down because I was tired from all the extra work I was doing that I was never supposed to have to do. Exact quote. I don't know what to, I can't help you then. You know what I mean? And there's nothing you're going to say to that person to convince them of it. So I think quick and easy, and don't give them an opportunity to have another person there who's going to complicate things for you.
On the flip side, though,
is that Wally from Dilbert?
It was from a firing that Max Barrick did.
But what I would say on the flip side is that especially if there's something sensitive from the employer perspective, I would have a witness present. I generally tell employers in most cases,
great point.
Do not terminate someone by yourself. Have someone else in the room. Have people write a memo as to what happened, who said what to who during the termination meeting.
Also, so if they need to call the police,
a witness. What
if they need to call the police or security or something like that? Yeah, you want to have somebody. You want to have somebody with free hands.
And you just want a third party there to corroborate or refute wild allegations or the truth, So for what Helen said, if somebody's litigious or crazy or dishonest, you don't want it to be your word against theirs.
Well, we're at the top of the hour. That was a great discussion. Thank you, everybody. Max, Helen, and Amit. We're going to be back for the last webinar in this series, number 7. AI at work. It's our second year of doing this doing that webinar. Legal issues concerning the use of AI in HR, and that's going to be on August 7th at 2:00 Central Standard Time. So thanks everybody for attending. Thanks to our panelists too, and see you all on the 7th.
Thank you.
Thanks, Chuck.
Cool.
Take
Thanks,
care, everybody.
everyone.